morning everyone in the Madras bar. It is an honor for me to be invited by the MBA Academy for being part of this web lecture series, and I thank the Academy for giving me this opportunity. It's great to be physically in Delhi and virtually in Chennai. The subject on which I shall be dwelling on today is essentially on the nature of collective ownership and common access to products of human intelligence. The term commons I have used here, borrowing from the English law. It essentially means the right of public access and use of certain specified lands. The equivalent to that, I guess, would be grazing porambok in our context. Different regions of our country have their own terminology for such land. I propose to explore with you today the manner in which new items of utility generated by the human mind are undergoing the process of being elevated to the status of property. This essentially implies that someone can own it and consequently rent it out against money. The expression non-real properties I have used here is mainly for two reasons. I had the option and toyed with the idea to use the expression intangible property, but the first reason why I use this specific term is to treat the subjects falling under it as property itself, but with characteristics different from real property. The replication right remains with the originator himself in respect of such properties. The other implication of the term non-real property is directed at certain works of mind, which include creative works and also works coming out of technological development, having widespread application. But these works lack the mortar and brick characteristic of properties as we commonly understand. Thinking men are exploring if these items can qualify for being termed as property at all or not. We are today in this web lecture in extraordinary times. The world as a whole is being ravaged by a virus which we still do not know how to deal with. There is a furious global race to find either a vaccine or a curative drug. What we read in the papers or the websites now is that most of the big-time corporate units who are undertaking the research for finding the magic ingredient are more or less surrendering the total control of such yet to be invented treatment options. The other development, bit unrelated to the pandemic, is clamor for controlling what is posted on privately owned but so far treated as public platforms. as the subject of my discussion today is primarily on what should remain in public domain, the intellectual commons. Both these developments are of some significance. Attempts have been made over the years to limit public access to internet, but such attempts have largely been thwarted, and access to internet still remains open to anyone having a phone line. There are of course exceptions where state authorities can block such communication on law and order ground, but still such instances are not very common, and in real world also temporary blockings of public space take place, like curfew or lockdown. Now, whether communication or search engines platforms operating on the internet should be treated to be in public sphere or not is an issue to be addressed. The legal systems at the global level are facing challenge in these two parallel fast-paced developments. As I have already spoken of, the first one is emergence of a virtual world operating through internet. One of the tech billionaires referred to the impact of internet as thousands of Xerox machines on steroids. The other area is intellectual property rights. Brands have now become main selling point of goods, and broad claims are being made over trading identities. In the field of technology, human beings are tinkering into life forms. Till now, Almight is exclusive domain. Ways of doing business on the internet are sought to be covered under patent law, though no real life articles come into existence through such process. New music and film swapping sites are popping up from far corners of the globe, to the horror of traditional copyright owners. Moreover, reach of this technology is cross-country, giving rise to conflicting interpretations of rights and obligations. No doubt, the new legal conflict zones in these fields require to be resolved by lawmakers. International treaties is one avenue the global community is exploring. But experience shows that increasingly the conflicts are reaching the law courts and are being adjudicated through the judicial process. The disputes which are arising out of day-to-day development of technology are generating legal controversies which call for creative solutions. In the lab, a new microorganism has been developed having commercial value. Will it be patented? What is the patentability of an isolated gene? Someone has created a website which gives a list of songs. Each member therein has in his file accessible to the rest. Does it breach copyright? Educational authorities are making photocopies of chapters from an expensive textbook for benefit of the students. infringement or fair use. A search engine has collected purchase habits region-wise of all their accessors. Do they own that information? Can they trade in it? Does the farmer have a right on new age second generation seeds, or the seed company can control the nature of use of its product? The title-based society is transforming into a tenant society. We pay EMI for our house, car, we pay license fee for the software on my computer or on our computer. We pay license fee for seeing the TV serials. So instead of owning a product, we are actually becoming tenants. Of course, private ownership has been part of the civilizational process since ancient days. An ancient Indian lawgiver had laid down the mode of acquisition of land ownership. What was this? One who removes the timber has the land. Today, the oldest surviving book of the world is the Chinese version of Vajrachedika Prajna Paramita Sutra of Mahayana Buddhism. This was created in the years 868 Christian era. Unusually, this book carries a public domain dedication. It ends with the colophon for universal free distribution. From this dedication, one possibly can infer that some books of that period must have had controlled distribution system. Saint Columba was directed by the king to return a copy of a book of Psalter of his former teacher about Finian in 16th century Ireland. The reasoning was, to every cow her calf, and consequently to every book his copy. In whatever legal term one describes it, some form of ownership always remained with the work of mind, possibly since the agricultural society emerged. But question is as to what was the nature of ownership. Was it exclusive, or its character was that of user right? There is an underlying common law theory that the property of the subjects is under the eminent domain of the state. We are familiar with this term since the decision in the case of Sir Kamesha Singh was delivered. There is some debate among historians as to whether the sovereign had such supreme right on land in ancient India or not. But the common law principle of eminent domain has got etched into our post-British jurisprudence. In respect of property, taking from few and distributing to many has been a tool for social reform at least since 24th century BC. Urukagina, a ruler of the city-state of Lagash in Mesopotamia, had confiscated land from the rich and powerful and redistributed it. This principle of eminent domain has also been applied in the field of intellectual property in early 2000 by different countries facing HIV epidemic. In South Africa, there was some kind of nationalization of this formula of antiretroviral drugs. Multinational pharmaceutical corporations were compelled to grant compulsory license to local manufacturers for such drugs. Threats to do so compelled the drug makers to reduce price of their products in respect of other potential public health hazards like the Asiatic influenza, anthrax, diagnostic tests for breast and ovarian cancer. Today my scope of exploration is existence of commons in the field of non-real property. In respect of real properties, historically started with commons and thereafter initially by desire, then by force and ultimately by law, the concept of title or ownership emerged. But for other kinds of properties, creation was by an individual or a group. The creator or inventor wants full control over the creation, but again there is a problem in protection of non-real properties, and the problem is that one cannot create a wall around them or keep them in safes. Theft of these properties occur not by removing them from the owner's custody, but by replicating them. These features have been described as non-rivalrous. When someone steals my laptop, I lose its possession and the thief has it. But when someone copies a firm's corporate data, the basic data may remain with the firm, but its value gets diminished when the same is copied in a pen drive and taken away for use in other areas. These non-rivalrous goods generate their title with their creators, and it is not my intention today to examine the manner in which they are sought to be protected. I shall go by the principle of to every cow the calf. Historically, societies have indulged in various mechanisms to prevent commonization of knowledge. Sanskrit, which is a treasure trove of our civilization, was so closely preserved that Bhagavan Buddha had to reach out to the common people with a different language altogether, Pali. There is the apocryphal story concerning Emperor Shah Jahan. He amputated or ensured amputation of hands of the artisans to prevent construction of another Taj Mahal. The modern version of such legal or illegal means would be a non-compete clause, which I guess would be a more human one. trace further back to the days of Mahabharata, you find Ekalavya offering his right thumb to Dronacharya to maintain secrecy of military technology. In Greek mythology, Prometheus was punished for stealing fire, a symbol of superior technology to enrich human civilization. Returning to modern times, questions arise as to what would confer ownership over something that cannot be physically owned, and what would be the pattern of exploitation or enjoyment of such ownership. Many firms want to evolve their market strategy via judicial decisions. In the process, there is a tendency to claim exclusive right on something which ought to belong to mankind. Of course, there are great inventors who have foregone their exclusive claim on philosophical grounds. The US Supreme Court, in the case of Diamond versus Chakraborty, the first case to recognize patentability of microorganism, observed anything under the sun that is made by man was patentable. However, Jonas Salk, the inventor of polio vaccine, declined to go for patenting his invention. There is no patent. Could you patent the sun, was his query or question. When does a creation come into public domain or intellectual commons? Because of their vulnerability to replication, legal mechanism has evolved in the field of intellectual property, conferring limited exclusivity over use or sale of such properties. But many times there are exaggerated claims. An entertainment company in the US held on to the copyright of the song Happy Birthday to You till a federal court found such claim to be invalid in 2016. Sounds, scents and colors are the potential new entrants in the field of trademark. There are some opponents of this kind of walls or boundaries against intangible properties, and they argue that such properties have developed basing it on common knowledge base and without the antecedents, an inventor may not have been able to develop a new theory or a new invention. If I have seen further, it is by standing on the shoulders of giants, said Isaac Newton. The broad theme of Shakespeare's celebrated work, Romeo and Juliet, was based on a novella by an Italian author, Matteo Bandello. Introduction of coffee in India is attributed to a Sufi saint who brought the beans from Yemen in 17th century. At that time, coffee from that country was fiercely controlled by the Arabs. Often apprehension is expressed by many that too much protection of technology may hinder further research. In 2001, a Russian computer programmer was detained in the US for violating copyright law. He was accused of cracking an encrypted material, as he had presented a paper on e-book security and had developed an advanced e-book processor for transforming the e-book format into PDF format. This was done by cracking into the encryption. Eventually, the prosecution was dropped against him on certain conditions, but main reason for such aggressive action by the IP owner originated from the very fact that digitization has permitted access to the community to huge e-highways. Through these highways, unauthorized copyrighted works can be transmitted, often by a single click on the mouse, or at present even by voice command on the mobile. So far as land is concerned, its origin was in commons. I have already discussed that. But for non-real property, it has a disclosed originator in most of the times. Trouble arises when such originator tries to appropriate the common stock of knowledge without which he could not have had made his work. There are numerous instances where an artistic work has been a step forward from an existing work. Rabindranath Thakur's well-known composition Ekla Cholore was based on the tune of a baul song, part of the Bengali folk tradition. Large part of technological innovations are made using creations of the past titans in the field of science. I have referred to Sir Isaac Newton's quote already. There are also instances when, left unguarded, many intangible properties which may have proprietorial attributes come to be associated with other traders of similar goods. The trademark jurisprudence referred to them as brands common to the trade or publicity jury. This is something akin to easement right in the field of land law. In patent law, the underlying principle which guides this legislation is an implied contract between the inventor and the general public, so that in compensation of limited monopoly, the inventor discloses the inventiveness so that science can carry on further investigation or research on the same subject. Today I have not tried to come to any definitive conclusion as to what should remain in public domain and public domain in intellectual commons, how they can be created. That is a matter of public policy. My endeavor today has been to highlight certain issues which are emerging both in legal philosophy and judicial fora. My objective is to set all of us thinking as to how much of the modern day properties we are willing to retain in public ownership and how much of it we are willing to be permitted to be appropriated by individuals or firms to make them monetizable commodities. This is again the task of the lawmakers, but whenever controversies of this nature arise, it is the legal community who are the frontline investigators on the scope of new rights and obligations. The bar of Chennai or Madras has been pioneer in raising many exciting and stimulating legal questions in the past. For me, it is a privilege to address all of you. I shall be glad if you spare thought on the subject I have deliberated on today, and this is absolutely necessary that a clear-cut legal theory emerges in regulating these non-real properties. By using this expression regulation, I don't mean control, but we should know the contours of the rights and obligations to prevent this field from becoming the wild west in law. I thank all of you for being patient and present through virtual communication system to listen to my web lecture, and I thank again the Madras Bar Association for giving me this opportunity. Thank you.